case briefs, and so much more. LSData's got what you're looking for.
The United States Court of Appeals for the District of Columbia Circuit was the battleground for the National Automatic Laundry and Cleaning Council v. Shultz case in 1971. The crux of the case lay in the interpretation of the Fair Labor Standards Act, altered in 1966, and whether coin-operated laundries and dry cleaning services were to be considered employees under this law. This litigation drew attention nationwide, with two formidable opponents locking horns: the Nationwide Trade Association of Laundries and Dry Cleaning Services and the head of the Wage and Hour Division of the Department of Labor. The point of contention? The status of coin-operated laundries and dry cleaning establishments as considered employees under the Fair Labor Standards Act. In a surprising move, the district court initially dismissed the case, claiming lack of jurisdiction. The Supreme Court, however, overturned the decision, arguing that the plaintiff had standing to sue. The court introduced a new test to substantiate its decision. The climax approached when the Supreme Court, after conferring due consideration to the legislative history and the presented arguments, sided with the administrator of the Wage and Hour Division. Interpreting the law and the exemptions offered under the Act's Section 13A, the Supreme Court underscored coin-operated laundries' status as subject to the Fair Labor Standards Act. The effect resulted in an affirmation of the 1966 amendments made to the Act, tagging the coin-operated laundry industry as squarely within their purview. The Supreme Court upheld the government's interpretation of the law, landing a blow to the Plaintiffs' Association. The case was then circulated back to the district court per the protocol for further proceedings, balancing the interests of the plaintiffs' members against the consequences of a premature enforcement review. As the curtain fell, the judgment echoed in favor of the administrator, the defendant in this landmark case, effectively defeating the National Automatic Laundry and Cleaning Council. But perhaps more importantly, it stipulated a more solid and clarified interpretation of the Fair Labor Standards Act and its 1966 amendments.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.